Everyone's been so friendly and nice to me since I got here yesterday. But Brianna left out the most important credential that I have. I've been a practicing notary for 25 years, first in Illinois and for the last decade or more in Florida. So I'm not here as just some egghead professor talking about something I haven't done. I've been acting as a notary also for a long time. I've been in the audience all morning listening to this program, and you've gotten a lot of very worthwhile information. I'm going to depart from what I'm assigned to do for just a couple of minutes because I would like to leave you with what I think are the four most important things we're going to get all day long in this program. As I've listened to my colleagues speaking and based on what I'm going to say to you, here's what I would go away with out of today's session if you don't already appreciate these things. First of all, as notaries, the moment that someone approaches us and asks for a notarization of a document, that's when the starter switch turns on and we go into notary mode. And for the rest of the time that you're dealing with that document signer and the document performing that notarization, it's one long process, and you are evaluating that signer's identification, their mental competence, their willingness. You're doing it through the whole process. It's not just for a little compartment of time that you identify them and a little compartment that you decide if they're mentally competent and so on. It's the whole time. Because at the last moment, just as you're getting ready to stamp the certificate and sign it and to say goodbye, if at the last moment something happens that causes you a concern, you're going to stop and deal with that and resolve it right then, because maybe you're going to refuse that notarization at the end. If you've been dealing with John Smith, the signer, for several minutes, but a colleague of yours walks past and says, "Oh, Fred Harvey, good to see you again," and starts calling that signer by a different name, you're going to deal with it. The notarization isn't over until it's over, until the ceremony ends. It's a continuing process. That's one thing. Second thing, I would start the journal entry, the record, immediately after someone says, "I'd like you to notarize my document." That's when to start that journal entry. Kathleen talked about several steps in the notarization process, and as always, she and I have been colleagues for years. We just did a 5-hour session in Dallas a few months ago together. I know that we're on the same page here. I'm sure she's not going to disagree with me much to say the very first thing after you know that you're being asked to do a notarization is to get the journal entry started then, because you want to start recording information. If shortly into the notarization, if you decide you're going to refuse the notarization and tell the signer that signer may walk away from you immediately and you've got no information about that person. Who was he or she? What's the address? What were they trying to get you to do? You want to record that in your journal, even if you refuse a notarization. That's my opinion. I think the people at the Secretary of State would agree with me that that's what to do, because with that change that they mentioned in the one statute, the statute is now referring to the record of your official acts. It's not just the notarizations that you actually perform, it's your record of all official acts, including a refusal to notarize. So start your journal entry right away. In addition, it's the guide. It will guide you through the certificate of notarization. Almost everything that's in the journal entry, well, most of it will also go in the certificate at the end of the notarization, but it will help you get things right. It will help guide you through the process. The third thing that I'd take away from today is to journalize. Journalize, journalize, journalize. That is so important, not just to start it early, but to maintain a record, create one for every official act, and to keep it. Keep it indefinitely. I know the statute says, or the regulations, at least 3 years. I would keep it indefinitely, forever, in other words. Here's the reason. I go out and consult on notary litigation, serious situations that occur around the country when there's a lawsuit involved, and I've testified in court cases about these. That journal is the most valuable tool you have. And I don't want you to think that it's important just for a particular notarization. The journal is evidence of all your history of notarizations, and if you get sued sometime and end up in an arbitration or a courtroom, that journal, the whole thing, will get into evidence. The judge, the jury are going to see all of your notarizations that you've recorded, not just the particular item. The journal, you see, is your important tool because it establishes a written record of what a good notary you are. If you are meticulous, you fill out every box, you give all the information, you do it time after time, you've got this whole book of how diligent you've been. You want the jury to see it anyway, but I'm here to tell you they will see it. I testified in California just a year or two ago on a case where a notary had been a notary for several years. She had 4 journals of over 1,200 notarizations. That's 1,200. The jury got to see all 1,200 of those journal entries in her book, and I told the jury during my testimony, I told them what a good notary she had been. I said she was diligent. She recorded every journalization. She didn't hide anything and so on. They were told about it and then went back to the jury room so that they could look at it and see that indeed I was correct, that she had been a very diligent, conscientious notary, and she was exonerated in the suit against her in large measure, not because of me, because of her good journal keeping. So think of it as the whole body of your work that will be seen. And if the Secretary of State, Kevin, just talked about the procedure for complaints, I bet in a lot of cases they're going to want to see the whole journal, not just a single entry on one page of your journal. And then the last thing, the fourth thing, is since you're doing so much writing, you're writing in the journal, you're writing on the certificate of notarization, proofread. Proofread, proofread, proofread. Before the very end, before you shake hands and say goodbye to the document signer, you take one last couple of minutes and you proofread your journal entry, see that it's all full. You look at the certificate, see that everything's there. You look at the seal impression, make sure you didn't smudge it or that the paper was off balance and it didn't all print. Proofread the journal and the certificate. In my experience, over the 20 plus years I've been serving as an expert, I could give you lots of examples of lawsuits that never would have happened if the notary had simply proofread. In my last case from Illinois, a notary was called upon to notarize 7 documents for a sealed bid process. And this notary notarized all 7 documents for the owner of a construction project or construction company that was going to bid on a government sealed bid project. The notary was a good, conscientious notary. She did 6 of them perfectly. On the 7th document for the bid, she forgot to put her seal on the one document. Those documents, and the signer didn't notice, those documents were put in the sealed bid. The government opened the bid, and a government agent discovered that one of the seals was missing. They rejected the company's bid. The company would have won the bid because it had the low bid. It lost over $100,000. The company sued the notary and the notary's employer for the $100,000 that it lost because of one missing seal on one of 7 notarized documents. If that notary had just looked at her work, if she had looked at her record book and then looked at her certificates and proofread them, she would have discovered there was no seal. Proofreading. So my suggestion, start the journal entry early, keep a journal, keep it a long time, proofread, and very importantly, realize that notarization is a process throughout the whole term of the notarization, those several minutes that you are there with the document signer. Now, specifically on the 2 topics I'm going to cover briefly with you today. I have an outline, not PowerPoint, but an outline in the materials. It's the last segment of the materials section in your book. It begins right after that biography of me. And on the first page, it says Texas Notary Education Program at the very top, if you find that. I'm going to cover these pages page by page. My first subject is, it's when and how to refuse, by the way. I just looked for the first real time at this. I'm talking about when and how to refuse to notarize. That's my subject here on page 1. To start with, a couple of preliminaries about this, beginning on page 1. After you're asked to notarize, you take control. You all have already studied the statute, the regulations. That's the best thing to do for everything we've talked about today. You take control of the process. You start from the very beginning to make the point that you are in control, that you are professional, that this is going to be handled in a professional manner for the document signer, and this is where that start button has come on. You've gone into notary mode. You're already beginning to think, is this really who he or she claims to be? You're thinking about identifying the party. You're thinking about whether they're mentally competent, whether they're acting voluntarily. You explain the notarization process briefly to the document signer, including things like you're going to ask for identification, perhaps, and I hope so. I'm going to suggest that to you. You're going to point out if an oath needs to be administered. You'll mention that. You'll explain briefly the things you're going to do. And I suppose, at the risk of putting my foot in my mouth here with some of the other experts attending the program, at the top of page 2, I would always ask for an identification. Even if you personally know the document signer, my advice is ask for identification. When I notarize for neighbors in Florida, which I do occasionally, even though I've known them for years, I ask for their identification, and I record it in my journal. In the journal, I record Florida driver's license. Now, you know, and you've been told a couple of times today, you don't record the driver's license numbers, social security numbers, passport numbers, but what you should record is the expiration date, month and year for that ID. So I'll record Florida driver's license and December of 2018. That proves that I really saw the ID. Otherwise, I could guess that somebody coming to me in Florida is going to have a driver's license. And don't put just down generic passport or driver's license. Put down the state, Florida driver's license, and the month and the year of expiration is my suggestion. If you put down the exact date, the month, day, and year, in some jurisdictions that corresponds to the birth date of the party, of the holder of the ID, and that might be then a very private thing that you wouldn't want to record. But if you record the month and year of expiration, that shows that you really saw the ID and you've recorded it in your journal entry. And remember, if something happens, the judge and jury are going to see the whole record book, not just that one notarization. So if hundreds of times you've recorded all this information, you're going to look good. You're going to look professional. You're going to look diligent. You will have looked like you exercised reasonable care, because you will have at that point. And incidentally, as long as I'm on it, I would ask for a signature always. I know that technically your Texas law does not specifically say to get the signature in the journal entry, but always, always get it there. This will help make you look like a diligent notary, and it will help you as a notary. Did you know that nationwide, the single most important fault that happens most often, so the most common, most serious fault across the United States with notarizations is that notaries do not require document signers to be present? They do let people come in and get notarizations of documents that have been pre-signed by somebody else. The alleged husband or wife will come in and say, oh, the husband or wife is sick, they couldn't be here today. Or the employer comes in and says, this good client couldn't get here in time today. And they'll have a document pre-signed, and the notaries will notarize. That's an invalid notarization at that point. That notary has violated the statute. That notary in most states has committed a crime. It's called official misconduct. If we violate the notary statutes, especially when we do it intentionally, and then we certify in the certificate that the document signer was present when they weren't, that violates the notary law, and that's a crime, official misconduct. The notary can be charged with criminal conduct there. So anyway, get the signature, because if you have a signature in your journal, the journal entry can't be pre-done, can it? It can't be pre-signed like a document can. That shows that the signer was really present at that point. And in most cases, the signer will sign a signature that should look like the signature on the ID documents, that should look like the signature on the document that's being notarized. So it also gives you that signature for comparison. And I watch people do the signature. I think you should too. Watch how somebody actually signs. Is it a natural flowing motion, or is it that contrived, halting, unnatural motion of an imposter who's trying to copy a signature that they've seen and they're trying to duplicate? It helps you to see the signature as well. You refuse to notarize in several situations in Texas and elsewhere, starting at the middle of page 2. When the notary should not notarize due to the notary's own concerns. First of all, this is sort of obvious, the first point, but believe it or not, people do this. Don't notarize before your commission is active, and don't notarize after it expires, all right? Make sure you've got your full commission in place, that you've got your bond, your seal. Make sure you have everything. Then you can start notarizing. And the one that happens more often, don't notarize after the commission expires. A lot of people lose track of when their commission expires. They don't read what it says on their seals, and they keep notarizing even after they're no longer notaries. Don't let that happen to you. That notarization would be invalid. And if notaries do it intentionally, that again violates the statute, the notary statute, and would be official misconduct. And of course, in Texas, your expiration date is in the seal. Just occasionally look at that so that you recall when your commission expires. Second time that you don't notarize has already been mentioned today, so I'll do it quickly. When you can't notarize your own signature, you shouldn't notarize any document in which your name appears at all, or especially as a party with any interest in the document. It's just, Texas has more than 400,000 notaries. The U.S. has almost 4.5 million notaries. There is no reason for notaries to be signing something with their own name or signature in it, or where they're a party in interest. Just don't do it. go down the street and get another notary to notarize at that point. Third point on page 3, you don't notarize when the certificate is incomplete or false. The notarial certificate that is usually pre-printed on the form, the instrument that's being notarized. Your statute there under point 3 says, the execution of any certificate as a notary public containing a statement known to the notary public to be false is a ground for revocation of the commission. That means don't do it. Don't do it in Texas or anywhere else. Now, there's some times when the notary should also refuse to notarize when there are problems on the signer's side. Those other things were problems we could have as notaries. There could be some things that go on with the signers that should cause us to refuse to notarize. Number 1, again on page 3, the first point, when there's an improper purpose involved. If you can tell, if you get an inkling, or if the signer says that they're going to misuse that document somehow, then don't notarize, such as they're going to use the image of your signature and seal to do a television promotion for a product or a candidate or some such thing. You should not be notarizing if they're going to do an advertisement, promotion, campaign, or some such thing with your notary seal and your name on it. Don't notarize if they're going to have an improper purpose. There under point 1, your statute says a notary is authorized to refuse to perform a notarial act if the notary has reasonable grounds to believe that the document in connection with which the notarial act is requested may not be used for, or may be used for an unlawful or improper purpose. So this is rarely that it happens, but it sometimes does. Number 2 there, at the bottom of page 3. The type of notarization requested is not permitted under Texas law, and if you read the regulation there at the bottom of page 3, a notary is authorized to refuse to perform a notarial act if the notary is not familiar with the type of notarization. Now, during her program, Kathleen mentioned a couple of things that I bet nobody in this room is familiar with. The lawyers in the room will know about it, but taking depositions and protesting commercial documents, marine protests, and so on, those are antiquated things from the 1800s that notaries used to do. I've never in my life been asked to do a protest or a deposition. I've never been involved in a legal case or testified in a case about any notary doing a deposition or a protest anymore. Those are hangovers, holdovers from old statutes that notaries don't do anymore because ordinary notaries shouldn't. Those are things that involve legal matters that are beyond the knowledge of most notaries. So there are a couple of examples, I think, where just about every notary ought to refuse to take on the notarization. On page 4, point number 3, and here I may get myself in trouble again with my good friends from Texas, but my point number 3, a conflict of interest of the notary exists due to a family relationship with the document signer. Now, for the record, in Texas, there are not prohibitions against your notarizing for family. You can do it under the law, but I would not do it. I would never, ever, ever do it for anybody in any lineage of my family. And I have refused numbers of my relatives who've wanted notarizations. I will not do it. You should not do it. I'm here to tell you. It's because you'll look bad. If there's ever a challenge to one of those, you're going to look bad. Judges and juries are ordinary folks who are going to think, why in the world, with over 400,000 notaries in Texas, why did she notarize her husband's signature? Why did he notarize his nephew's signature? There's just no need to do it. You're going to look bad because blood does occasionally cause conflicts of interest. There's that family tie that may have an effect, and even if you would have no effect, if it would have no effect whatsoever on you, I would recommend you don't do it. Remember, the standard is that you have to act with reasonable care. You want to impress judges, juries, investigators from the Secretary of State's office. You want to impress them with the fact that you are honorable, diligent, professional, and above board all the time. Don't take the risk, is my personal opinion. Point 5, financial conflicts. If you have any direct or indirect financial interest in the document being notarized, don't notarize. Don't notarize. Even if there's an appearance of a conflict, don't do it. Appearances are just as bad as actual conflicts most of the time. Number 5, a technical fault in the document. Blank spaces. Kathleen's already mentioned this for me, so I don't need to go over it. If there's something like that, or if the document and the signer speaks a foreign language, the document is in a foreign language that you're not familiar with, and most importantly, the certificate of notarization is in a foreign language. If the certificate is in a foreign language with which you're not familiar, you should never, ever, ever notarize that document with that certificate, because that's where you certify what you've done. How can you certify what you have done if you can't read it? You shouldn't rely on somebody to interpret it for you. Never, ever do that. Number 6 is the biggest one of all, but half the other speakers have covered this, so I'm not going to do it. If the signer is absent, if the signer is not present for the notarization, you always refuse that notarization. And incidentally here, take an aside with me, a footnote to this. Anytime that you refuse one of these, and this would be the big one, if you ever refuse a notarization, put that refusal in your record book. All right? To say again, if you refuse a notarization ever, put that refusal in your record book. It's an official act. You as a notary have officially decided you cannot notarize, so you should record that official act. And I'm here to tell you, you want to hope that someday you get to refuse a notarization. Now, I don't want you to misread this. Please, do not go out and refuse the next person who comes to you just so you can get a refusal in your record book. I'm not telling you to do that. But I am telling you, if you get to refuse sometime, and then after that sometime, if you get in trouble with the Secretary of State or you're in a lawsuit, judges and juries love to see that you are so diligently that if need be, you will refuse a notarization. You're not a rubber stamp. You don't just sign off on everything that comes before you. In the case I mentioned to you when I started today, the case of the notary in California who had done over 1,200 notarizations that the jury got to see. Those were in 4 journals, by the way. She had kept all her journals. She was a good notary. Kept them for years. She had all 4 books, over 1,200 notarizations recorded there. They got to see all 4 books, all 1,200 notarizations, and she had refused a couple of notarizations. Over the years, she had refused a couple of notarizations. And this was a case about her allegedly doing something improper, fraudulent. The case was about her conspiring to falsify a notarization. Those jurors got to see that this lady was so diligent, she had recorded all this information for all these years, and she had refused some notarizations. So they got to see that she wasn't just a rubber stamp, that she didn't take her duties lightly. She was a responsible, diligent notary. It helps if you ever have to refuse one. It'll look good if you're ever challenged. But again, don't refuse just to get one in your book now, or you'll get me in trouble. At the bottom of page 4, number 7, if you cannot identify the document signer with reasonable certainty, this shouldn't happen ever really, but it could be that an instance will happen where a signer offers you some kind of identification, but it's not good enough. You'll ask for another document or two. They won't fully satisfy you. If you get to the point where you just can't identify the document signer with reasonable certainty, you should refuse that notarization, right? You've got to positively identify the signer. Now, incidentally, the law doesn't require us to get it right. All we have to do is use due care, reasonable care, make our best efforts to identify the document signer. If a skillful forger gets past us, they've got a good story, they've got good-looking documents, ID documents, and we notarize for an imposter, if the notary has used reasonable care, the notary is exonerated from negligence liability. You're not liable. So use best efforts to identify the document signer. I didn't even tell all the lawyers we got together last night for dinner. I'm sure that doesn't sound terribly exciting to you, but we had a good time at dinner last night. The lawyers and I from the Secretary of State's office. And I didn't tell them, but I'll at least tell you that last week, Friday, as I was starting to think about packing and coming here to Texas, I got a call from Texas. I thought it was going to be the Secretary of State's office, but it wasn't. It was a private attorney from Texas calling me with a case about the forgery of a signature on a real estate document that had been notarized by a Texas notary, and wanted to talk to me about this case. And preliminarily over the phone, we do some preliminaries with this lawyer. I asked for the basic details of what happened. And the lawyer explained to me what occurred, and I especially wanted to know about the notary. Did the notary keep a journal? Did the notary see identification? Did the notary get a signature in the journal? Yes, yes, yes was the answer to all these. And so I ended up saying, if your case goes forward, I will be pleased to consult and come down if necessary and testify on behalf of that notary based on preliminaries. Now, I always qualify that if after I see all the documents and so on, if something there changes my view, I'll let you know and I'll refuse the case. I won't testify for the wrong side in a notary case. But there was a case from Texas, recent vintage, where indeed an imposter forged a signature, got a notarization, but the notary had acted quite diligently in my initial judgment. So I'm willing to side with the notary on that case because notaries don't need to be perfect. We don't have to be perfect. The law doesn't require that. We just have to use reasonable care to identify document signers. On page 5, I think that's where I am at this point. Point number 8 there. The notary cannot communicate with the signer, cannot communicate, and here we're talking about orally with the signer, with the document signer. The notary needs to be able to communicate, and it could be by sign language, for a notary and a signer who both understand sign language. But if the document signer speaks a different language than the notary, it becomes very difficult for the notary to determine willingness, mental competence, and really to do a thorough investigation of the identity of the document signer if they don't speak the same language. And with an interpreter, We can't really get the same feelings, impressions. We can't do the same readings. We can't even read body language of someone in a foreign language if we don't speak that language, right? You don't know what that body language is related to. So a notary should refuse a notarization if they can't communicate with the document signer, because, and it's not just because they don't know the language, it's because that then denies the notary the ability to assess identification, willingness, mental capacity sufficiently to do a notarization. Point number 9 at the bottom of page 5. The notary should refuse, and your statutes and regulations say that expressly. The notary should refuse if the signer is not acting voluntarily. At the bottom of page 9, the regulation reads, a notary is authorized to refuse to perform a notarial act if the notary has reasonable grounds to believe that the signer is acting under coercion or undue influence. And at the top of page 6, point 10 is you do the same thing if the signer appears to be mentally incompetent. The regulation reads this way. It doesn't use mental competence, but this is the language equivalent of it. There at the top of page 6, the regulation says a notary is authorized to refuse to perform a notarial act if the notary has reasonable grounds to believe the signing party does not have the capacity to understand the contents of the document. Now, I'm here for less than half an hour at this point. There is not enough time to cover willingness and mental capacity thoroughly. A couple of months ago at the NNA, the National Notary Association's annual meeting, a fellow lawyer and I were on the program for 2 hours to talk just about the mental competence issue, and we didn't finish our material 2 hours later. So this is something that could take a while. But I can tell you a couple of quick things about willingness and mental competence, because I want you to feel somewhat at ease, but I do want you to give thought to this issue. There are reference materials out there you could read if you wanted more, and we'll be here to answer questions after the session. But the notary is not expected to be a psychiatrist or psychologist. We're only with the signer for a brief period of time, minutes at most, almost always. So we can't do a full mental assessment, and reasonable minds can differ. We just have to get a lay person's impression of whether someone is acting voluntarily, whether someone appears to be mentally competent. Ask a few questions about to make sure they're grounded in reality. They know what year it is, who's the president, those kinds of things. If there's somebody present in the room, a visitor or somebody who's come with a signer, I usually ask that person to leave for part of the time when I'm doing these questions, just so I don't embarrass the signer, and especially if the visitor might be connected with the document. If the visitor is connected with the document, has an interest in, is the beneficiary of the document, the signer might be there to sort of put pressure on the signer to go ahead and execute the document. But we aren't required, again, to get it right. We are required to use diligence, reasonable care, to take steps to attempt to determine whether somebody is willing and mentally competent in the few minutes that we have to spend with them. And if you have questions, I'll be happy to answer them. And Kathleen and I have both agreed that we're going to stay beyond the end of this program. At 1 o'clock, we'll stay as long as you have questions, any of you. And we're not going to force all of you to be here, but those of you who want to stay and ask questions, we'll stay as long as it takes to get your questions answered. Quickly about the employer can limit notaries' performance of notarization. So the notary can be required to refuse to notarize for a private employer, but it's basically an all or nothing thing. If a private employer says, I don't want you notarizing at work because it takes you away from what I'm paying you to do, the employer can do that. An employer can say, I don't want you notarizing on business time, at the business, and so on. For one thing, the employer may not want to have liability in case something goes wrong, but the employer also has a right to say to you, I don't want you doing those things on my time, on my clock, on my payroll. There are some bad reasons there, not to be so that you don't refuse for bad reasons, but you can read that. How to do it real quickly, because I have another subject to cover. This is on page 7. How to do it. If you are going to refuse to notarize, you have to be firm. Don't equivocate. Be firm. Say, under the law, I cannot notarize for you under these circumstances. And that's point number 2, place the responsibility on the law. This isn't you just feeling that you don't want to do it. This is you refusing because your legal responsibility is to refuse. So instead of you taking the full responsibility, you say, no, I cannot do this because the law will not allow me to notarize. And record the refusal there. Record the refusal, as I said. It can be very helpful. On page 8, avoiding the unauthorized practice of law. This is at one and the same time a very complicated matter. What is the practice of law is not clear-cut. But on the other hand, most of the time, almost all the time, it's pretty straightforward that just stay away from pretending to be a lawyer. Even if you're not saying that you're a lawyer, pretending that you know enough to give advice and do the things that a lawyer would do. Let's get to some of the detail and let me give you a few specific pieces of advice to keep you away from the unauthorized practice. Because for sure, the most important thing of all, I suppose I'm going to say, is unauthorized practice of law is prohibited in Texas and everywhere else in the United States. It is against the law. It's against the notary law, it's against the common law, it's against the criminal law, it's against court rules. If you engage in the unauthorized practice of law, you're going to run afoul of a bunch of statutes and regulations. Lawyers, by the way, have done a really good job of protecting their turf. They have done a really good job. You know that many state legislators are lawyers, a lot of elected officials are lawyers. Lawyers, since the beginning, have protected the practice of law from encroachment by non-lawyers, all of those lesser people out there, I guess. No, and I'm playing with you a little bit, but as a lawyer myself in my earlier life, I know what goes on there. So preliminarily on page 8, I've already said you're going to run afoul of a bunch of statutes. There are some real sound reasons, though, besides my emphasis on lawyers wanting to protect their profession. There are some good reasons that we don't want non-lawyers doing the things lawyers do. Non-lawyers are not qualified by education and experience. You know, lawyers do go through 3 years of law school. They have to take a bar exam in almost every state and territory in the United States, so they have a lot of education about lawyering. They're tested about it. A second thing is that there are rules of conduct for lawyers. There are codes of professional ethics, court rules, and so on that govern their behavior, and they need to abide by that or they will get themselves disbarred. The third, and maybe the most important thing of all, is they have malpractice insurance. And in a lot of states, they're required to carry malpractice insurance so that if they do something wrong and a client is injured financially, there is a source of compensation. No state in the United States, not one state, requires notaries to carry liability insurance. Half or less of the states require notaries to be bonded. So in half the states, you don't have to have any bond. In the others, you have to have a bond, but it's only $10,000 in Texas. The highest bond anywhere is $15,000. That's peanuts these days. Notaries should not think that they have adequate protection just by having a bond. Besides, as Kathleen pointed out, if you have a bond and there's a claim against your bond in Texas, and if the surety company pays on that claim, you have to repay the surety company. So if you got a $10,000 bond and they pay the full $10,000 to some claimant, you have to pay the company back the $10,000. It's not insurance. It doesn't work that way. Only if you have errors and omissions insurance, or what we call malpractice insurance, only if you have that kind of insurance will you not have to repay the insurer or the surety company that pays on a claim. So lawyers are educated, lawyers are governed by very specific rules of conduct, and lawyers either are required to have malpractice insurance or are sensible enough, because lawyers get sued so often for malpractice that almost all of them are sensible enough to carry big-time malpractice insurance. So those are the reasons we don't want non-lawyers practicing law. What is the unauthorized practice of law? Starting at the bottom of page 8, what is it? Well, it's the easy things that you see on TV. It's the Perry Mason kinds of things for people who go into courtrooms or arbitrations or administrative hearings, people who go in to represent someone other than themselves. If they go in to represent friends, neighbors, clients, etc., then they're making appearances on behalf of those parties. That's the unauthorized practice of law. But that's so obvious, that's easy. Let's look at the other things that become unauthorized practice. Page 9, number 2. Claiming to be a licensed attorney or creating an appearance. So you can either say it in words, written or oral, or you can create the appearance of that with false and misleading kinds of advertising. And I'm going to get to the things that you were told about regarding the statutory changes where people claim to be immigration specialists or immigration advisors and notarios and all that. We'll get to. Providing legal advice, consultation, opinions, preparation of legal documents. There on page 9. That's the big one for notaries. Notaries who are drawn into giving advice about the documents that they notarize. That's the riskiest area for unauthorized practice of law. And the temptation comes because document signers come in with their documents. Sometimes they've read them, sometimes they haven't. Sometimes they're pretty well informed, sometimes they're not. But they tempt us with questions. Do you think this is a good idea for me to sign this will? What does that mean there? Party of the first part does this to the party of the they ask questions. And we, as good people, public servants, your instinct is to answer a question that you're asked. Well, get rid of that instinct here. Don't be too quickly forthcoming with answers to questions about documents. I'm going to tell you in just a page or two, and I promise I will speed ahead and get there, but I am going to tell you one of my best tips for avoiding unauthorized practice of law is do not read the document you're notarizing, of course. Do not read the document. Kathleen talked about scanning it. She said scan. She didn't say read. Peruse it. Look to see if there are blank spaces. You don't need to read it to see if there's a blank space there. You need to know the kind of document. You only have to read one word at the top of most documents. It's going to say will, contract, mortgage, whatever it's going to say. Don't read the document. Why? Because then, if you're asked questions about it, you can hardly answer a question if you haven't read the document, unless it's some general question. Should I have a will? Nobody asks that. They ask about their document, right? So if you haven't read it, you can't answer it, and you shouldn't answer it. So don't get drawn in. Don't give advice. Don't read the documents so that you can't give advice. Bottom of page 9. And especially in Texas and some other southern tier states, do not use the term notario or notario publico, those Spanish, Latin phrases. Notario, notario publico are off limits to notaries everywhere because, and I'll only take a moment, you probably know this, that in the Hispanic countries especially, notario or notario publico describes a public official who is both a lawyer and a notary. That's the problem. In those other countries of the world, the Hispanic countries with Hispanic heritage, notario means something different than the ordinary notary of the United States. And notaries in those countries have far greater responsibilities than we. Indeed, notaries in those countries are engaging in things that constitute the practice of law in the United States. So for a U.S. notary to use the word notary or the phrase notario, or the phrase notario publico will mislead some individuals from with knowledge of those countries. So we do not do that. And you should read the detail on page 10 about what not to do. You can't even use those phrases and then put an English translation there explaining what you really mean. Don't use the phrases at all. Including, in the middle of page 10, use of non-English advertising. You've got to watch what you do, and the Texas provisions are there on page 10. I think I should read one or two of these at the bottom of page 10. A person commits an offense if the person is a notary public and the person advertises the services of a notary public in a language other than English, whether by signs, pamphlet, stationery, or other written communication, or by radio or television, if the person does not post or otherwise include with the advertisement a notice complying with this next provision at the very bottom of page 10, which says, the notice required must state that the notary public is not an attorney and must be in English and in the language of the advertisement and in letters of a conspicuous size and so on. So even if you use phrases other than notario and notario publico, if they are in a foreign language, you have to comply with this provision and you have to post a disclaimer notice saying that you are not a lawyer licensed to practice law. On page 11, Kathleen referred to this earlier. I'm going to repeat it. Even selecting the kind of notarial format is considered the unauthorized practice of law in Texas. Now, I personally disagree with that, but Texas has done a really good thing here. They've done this the right way. This is all about the situation where a signer comes to you with a document, but there's no certificate of notarization attached to it, right? That's when this will happen. Somebody gives you a document, but they don't know how it needs to be notarized. And so they look at the notary and say, what should I do? What kind of notarial form? What kind of notarization should I get? In Texas, you should not give advice about what form of notarization to perform, but instead, if you read the material there at the middle of page 11, you will see that in Texas, what you should do is you should show the individual the three different forms of notarial act, the acknowledgement, the jurat thing, the signature witnessing. These are the forms that you are given when you get your notary commission. So the Secretary of State has done your work for it. In the packet, you get the sample forms. You simply offer those to the signer and say, these are the various forms, and you have the signer select which form of notarial act. If they don't know, if they're confused, you say, perhaps you should consult a lawyer and come back to me when you know which type of notarization you want. But that's a good solution that Texas has come to. The notary doesn't give advice, but does help the signer by offering these choices, shows them the form. If they pick one, you can go ahead and just type or attach or even handwrite that form at the end of their document, do the notarization, and there you have it. At the bottom of page 11, I'm going to mention that and then quickly what the steps to avoid the unauthorized practices. At the bottom of page 11, in my experience over the years, the people who get in most trouble about the unauthorized practice of law are people who are notaries. I mean, when notaries get in trouble, the ones who get in trouble are the people who are also professionals in law-related fields. If you're a notary and a real estate agent, you're a notary and a banker, you're a notary and a paralegal, you're a notary and a certified public accountant. That's the one that maybe most often gets in trouble. Because of the fact that you're a notary and you have all this training and experience in a law-related field, there is greater risk that you're going to get tempted and involved with things that involve the unauthorized practice of law, or at least may get close to it. So the caution here is that for people who are professionals in law-related fields, be very careful about how far you go in terms of consulting, preparing documents, those kinds of things. If I can say one quick thing about conflicts of interest, this is a footnote to this matter. I'm also one of the many people in the world who think that it is improper for someone who is a CPA, a banker, real estate broker, and so on, if they prepare a document for a party, a client, they should not also be the notary. And by the way, I think that lawyers who prepare documents for their clients should not be the ones notarizing those documents. Unfortunately, in my opinion, lawyers all over the country are doing this every day. Lawyers are preparing documents for their own clients, and then they're notarizing the documents they've prepared for their own clients. Wow, doesn't that sound like a conflict of interest? It does to me. And same thing for an accountant or a real estate broker who prepares a document for their client, and then the broker or the real estate agent notarizes it also. I wouldn't do that. With 400,000 notaries here, 4.5 million in the US, you don't need to. I wouldn't do it. I swear to you that if such a notarization is challenged, judges and juries are not going to think well of that. The gut reaction, initial instinct, hearing that you've notarized for your spouse, that you've notarized the document that you yourself prepared, the gut reaction of most ordinary people is, that just smells bad. That isn't right. I wouldn't have done that. So this again is my opinion. The Texas statute does not forbid lawyers and other professionals from preparing documents and notarizing them, but I think it is not a good idea. Some steps here on page 12. Steps to help avoid the unauthorized practice of law. Number one, advise clients that you are not an attorney. even post a sign, put it on the back of your business card. I actually handled one of these cases in Illinois for a fellow, not a notary, but an ordinary citizen who was doing some things so that the Bar Association charged him with the unauthorized practice of law. And if it ever happens to you, it's a very uncomfortable situation. This is expensive, time-consuming, intimidating. In Illinois and other states, a panel of lawyers who are commissioners of the state Supreme Courts usually, but a panel of some people who are appointed or designated in Illinois, 7 commissioners of the Supreme Court of the state, sit on a panel and hear these cases. It's like a trial before 7 judges. And so this fellow was charged with the unauthorized practice of law and went in before these commissioners of the Supreme Court because he had been so charged. In his case, he had done what I'm suggesting here. On his answering machine for his business, he had a message that said, "Hello there, this is so-and-so, and I am not an attorney licensed to practice law, and I cannot give legal advice." And he had a little sign like that, not too little. If it's too little, it's inconspicuous. But he had a sign that was big enough, posted on the wall of his office that also said, "I'm not an attorney, cannot give legal advice," and so on. That helps. That helps a great deal. That's one of the things that he did. I'll tell you about a couple of others as I go quickly through this, but it ended up we managed to get all 7 commissioners to agree that he had not engaged in the unauthorized practice of law. This was remarkable to me. I expected the worst because that's often the outcome of these cases, but all 7 agreed, and one important reason, he had done a sign. Let's go through the other ones quickly here. You don't do deceptive advertising, of course. You publish your notary fee schedule. What lawyer in the world is charging $4 or $6 for anything, let alone legal advice, right? So post the sign. Sure enough, we got the fellow to testify before the commissioners. We asked him what he was getting paid. He was getting paid peanuts. None of those commissioners thought that he was getting paid for what you would expect somebody to be paid for giving legal advice. So post your fee schedule. Don't read the document. That's the big one. If you're making notes, circle that, underline it, whatever, number 5. Do not read the document. You can hardly be pulled in and tempted if you haven't read it. Number 6 is similar. You don't answer questions. I simply separated them there. Don't answer questions. That's the usual method to lead to unauthorized practice. You sit there doing your job and the signer starts asking you questions and you get tempted in. Don't answer questions. Kathleen mentioned this earlier. This is so important. Number 7, do not make any changes or additions to the document to be notarized. Don't ever write beyond the 4 corners of the certificate at the end. The certificate is for you. The document is for the signer. If you avoid doing that, you also will avoid a big temptation. Oh, let's modify paragraph 7 here. Let's do this. That's not a good idea. Let's strike out that. That's where notaries can get into trouble. Don't make changes of any kind. Don't write in any area outside the certificate and your journal record, of course. You don't review, draft, consult about the documents. Number 8 there on page 12 is for those notaries who are in law-related professions. I've already mentioned that. Refer clients to lawyers for legal advice. If they start asking questions, then they are concerned, they're uncertain somehow, so that's the time for you to say, I am not an attorney licensed to practice law, I cannot give legal advice. I would suggest that we delay this notarization so that you can obtain the advice of a lawyer. And by the way, once you've done that, if they say, oh no, let's go forward, I'd be sure that I put a note in my journal entry about that I gave them, I suggested they get legal advice and they declined. That would be in my journal entry. Kathleen had that lovely PowerPoint of a journal entry and multiple, or was one of the other speakers, I guess, who had that. You don't have to stay in the lines and the columns and boxes. Some of the lines and columns and boxes wouldn't be appropriate for what I just told you to do. To write a note that said, the signer asked for legal advice, you declined and recommended he or she gets an attorney. There's not a box for that. But it's important, so you get it in there. If you have to take 2 or 3 lines where other notarizations would have been recorded, do it. Neatness is not the important thing for juries. What's important is the information that correctly records the notarization and helps you, the notary, and in turn, the signer and people who rely on the notarization and so on. I don't want to sound too selfish here. It's not just for us. It also protects our notarizations and protects the public. But that's the important thing, not whether you stay in the lines and boxes. So write as much as it takes, take up as much space as you need to get it written. And of course, the 10th point, journalize. Journalize, journalize, journalize. Here's another tip. Do I have it there? Yes. Look at number 10 on page 12. Keep and preserve a notary journal and record start and end times. Now, that's not in any of the boxes, right? It's going to say the date of the notarization. I'm here to tell you that it wouldn't be a bad idea for you to record when you start and when you end. You know why? That's going to be a really little period of time, right? It's going to be minutes. What lawyer calls you into his or her office for 3 or 5 or 7 minutes? And how much very significant legal advice could be done in 3 or 5 minutes, right? If you've recorded the length, the duration of your notarization, and then somebody says, oh, they told me all about how to make a will, and it would be impossible, right? You record your fee. In the journal, record the fee that you are paid for the notarization part, because that's going to be small again. Compared to what lawyers charge, it's going to be trivial. It's going to be tiny. These things help. I know that I'm being a little bit lighthearted, and some of you are smiling, chuckling, as I've mentioned a couple of these, but I'm dead serious about it. These things will help if you get charged with the unauthorized practice of law, because the judge and jury or commissioners are going to see your journal records. They're going to see all of them, not just the one for that incident. They're going to see all of them. And if you want to look good, that's the way to do it, right? Well, I'm trying to end maybe even a minute or two early so that we can get to our panel. All right. Thanks for having me. I hope it was helpful. We're now going to have a panel to answer questions.